Welcome, everyone, to another one of our podcasts. When I say another one here at SERMA, I mean it's the first one because we're actually changing our vlogs into podcasts. So this is actually our kickoff official edition of the SERMAPod. We're very privileged to have a couple of amazing guests. Before we get into that, let me remind everyone what SERMA is and why we're doing these podcasts. SERMA is the Sports and Entertainment Risk Management Alliance. We've been around for a few months. Our goal, our mission at SERMA is to be the clearinghouse, the marketplace for discussion, networking, education, sharing of ideas in the sports and entertainment, risk management, claims, insurance, legal world. So towards that end, we have a lot of content that we've already developed. We have three great vlogs that are a little bit shorter versions of what we're doing today. One was on the liability implications of the Will Smith slap. That was really interesting. We did one on the Johnny Depp trial while it was still going on. We'll do some more content on that coming up. And our last one was a really interesting discussion on name, image, and licensing issues with a couple of great experts in that area. So check us out at theserma.org. With that all being said, I'd like to introduce our amazing panel. First, we've got Professor Tom Baker. Professor Baker is the William Measy Professor at the University of Pennsylvania, where he's on the faculty of the Carey Law School and the Wharton School of Business. His COVID coverage litigation tracker is the definitive source of information about U.S. COVID-related insurance litigation. Tom's prior research has explored D&O insurance and securities litigation, professional liability and insurance, the behavioral economics of health insurance exchanges, cyber insurance, the regulation of robo-advisors, and the rise of insurance runoff market. Beyond his academic work, Professor Baker regularly serves as an insurance litigation consultant and expert witness, and he is co-founder of Pickwell, which uses big data and behavioral economics to build benefits decision support tools. Professor Baker, it's an honor to have you on our first SERMAPod.
I'm delighted to be here.
We've also got Michael Gehrt, who's a partner in the Manhattan Beach, California office of Pasich. I knew I would screw that up because we talked so much about it. Pasich, LLP, an insurance recovery firm with offices in New York and LA. Michael represents insurers in a variety of complex insurance coverage matters, including coverage advice, pre-litigation disputes, international arbitrations, and coverage litigation. Michael has been instrumental in collecting hundreds of millions of dollars on behalf of insureds and, in the last few years, has advised numerous clients on insurance issues arising from the COVID-19 pandemic. Michael, welcome to the podcast.
Thanks, it's a pleasure.
So just to frame our discussion, obviously over the last couple of years, we're dealing with a brand new area in many ways of coverage disputes, and those disputes deal with COVID-19. And we've seen obviously a flood of claims and litigation surrounding this area. And what we're talking about today is how those claims have arisen and how they've developed specific to the sports and entertainment industry. So Mike, why don't you give our listeners and our viewers a little bit of background as to sort of how we got to where we are. We're going to talk about the status of the claims and litigation, but give us a little bit of background as to how we got where we currently are.
Sure, happy to. So, as we all know, the COVID-19 pandemic came a little over 2 years ago, and a variety of businesses, including sports and entertainment industry businesses, including sports teams, venues, agencies, what have you, all suffered, substantial losses as a result of the COVID-19 pandemic and the response to the COVID-19 pandemic. We know that there was closures, there were government shutdown orders, there was social distancing requirements. A lot of public spaces were closed down for a significant period of time, and travel was significantly impacted. And of course, people wanting just to stay home and stay safe. All of that combined to create fairly substantial financial losses for a variety of business, including sports and entertainment businesses. And so what happened within, I want to say, weeks or maybe even less, there was quickly a turn to there various insurance policies that these businesses had to determine whether or not there may be some insurance coverage for these losses, as you would expect. And unfortunately, at least from my perspective, the ones that jumped on this rather quickly were a lot of smaller businesses represented by attorneys that were, I'm sure, well-meaning, but were not insurance coverage attorneys, had not spent their career practicing in this area, but I don't want to be pejorative, but I think saw a substantial amount of litigation coming out of this, and jumped on those cases rather quickly, and filed lawsuits very quickly without very developed allegations, simply alleging that they were, they'd been damaged, and here's our claim, and it's been denied. Others, took a little more contemplative approach, looked at the various policies, analyzed those policies, because they were not one fit all for every business or industry. You have a variety of different types of policies that can come into play, and just because you have one insurance policy doesn't mean that it's necessarily covered. There was a significant difference between those early cases and cases that came later. And so the one of the critical differences for me, one that kind of stuck out as in the summer months rolled along and more claims came and more lawsuits were filed, is the stark difference between many of the policies that these insurers were issuing, including to their sports entertainment clients. You had a lot of the early cases that, and Professor Baker can speak to this, a lot of the early cases you dealt with policies that had a very clear virus exclusion that said there's no coverage for losses caused by viruses. And courts were with relative ease set those cases aside and dismissed those cases. But a lot of these policies did not have that virus exclusion. A lot of these policies provided communicable disease coverage, which was not at issue in any of the earlier cases. A lot of policies, and this is particularly relevant for the sports entertainment, would not be property policies at all. They'd be event cancellation policies that don't have some of the language that I'm sure we'll get into later that the courts have focused on. So I hesitate to say that this is one size fits all. There was a whole lot of claims starting in the very beginning, but it's important to note that they were coming from different businesses with different types of loss on different policies with different policy language. So I think the insurance industry has done to its credit a good job of making it seem like these are all the same, but they're not. Policy language is different, the losses are different. So we started off with a whole host of claims coming in, and that is then filtered through the lower courts now in large measure, and now we're up in the Federal Court of Appeals and the State Court of Appeals on a variety of these claims.
All right, and we'll get to that in a moment because that's really interesting. But Professor Baker, maybe you could give our listeners and viewers also some historical context about how the language of these policies dealt with these kind of similar issues in the past, but yet weren't really equipped to deal with specific COVID-19 claims because they are so different from everything else we've seen up until this point.
Sure, I'm happy to do that. I mean, one of the kind of coincidental, fortunate things is that a lawyer who represents insurance companies wrote an article that was published in December 2019, just a few months before the pandemic arrived in America, and which he went through really, all the prior court decisions on the question of, what do you need to have in order to qualify under language that typically goes, is there physical loss of or damage to property? Most, not the event cancellation policies, not the cast insurance policies that Mike was talking about, but your sort of standard property insurance policy that includes business interruption coverage. In order to get access to that business interruption coverage, you need to have this physical loss of or damage to insurance. Damage to property. And so this fellow wrote a review in the December 2019 of the prior cases. And there were cases like methamphetamine fumes in a building, cat urine smells in
That's
a
the favorite one.
Yeah, cat urine smells. We have bacteria in wells. We have gasoline fumes. We have homes that are not teetering, but homes where there's been loss of property sort of around the home, but the home itself is intact. And there's a whole variety of, the kinds of things you can't make up, right? That's the great thing about court lawsuits, is they always involve things that you can't make up. And, and he went through that and showed that the courts were sort of all over the place on those, that there were some courts that required what has come to be called sort of tangible injury to property, structural damage, and there were other courts that didn't require that. And sort of that's the backstop to what happened. But none of those cases were pandemic cases. And so then, we come into March 2020, and as Mike said, the insurance industry took a just say no, result that, in retrospect, who can fault them? It's been successful so far, and really began to treat this like a mass tort with a very sophisticated, well thought out strategy where they put their A team to work from the very beginning, geared up a massive public relations effort. I mean, I sort of AstroTurf public relations effort that seemed like sort of spontaneous, but of course it was not, directed at all the things that would happen if the courts were to decide that these things were covered. And, and so I started dealing with my COVID anxiety by creating this COVID coverage litigation tracker that we talked about. And, people like, law professors like me thought that what was going to happen was going to be a kind of ground warfare where policyholders would win some, insurance companies would win others, and we could use this opportunity to study things about like what influences judicial behavior and all that kind of thing. But instead what happened is pretty early on, in part because of the dynamic that Mike described, I think, the carriers won the early rounds because people filed weak cases that we now in retrospect think were weak, and part of that was an effort that Mike didn't mention but is worth remembering, is there was a big effort to have these cases be considered an MDL, which is a kind of federal court procedure where you sweep into one court in one judicial district all the cases nationwide that have a lot of things in common. And the insurance industry objected to that strenuously on the grounds that these policies are all different, these cases are all different. Ironic, right, Mike?
Yep.
And beat that back. And so one reason why a lot of, let's say, weaker cases got filed really fast is people were competing to be running that MDL. And one of the ways that you win the competition to be running an MDL is to have a lot of cases.
Yep.
And you can see that the way that in our data you can see that most clearly is, we did a chart. It's out of date, so I can't show it to you, where we basically plotted the population in a state compared to the number of these lawsuits in the state. And mostly there was a really close correlation with three outliers: Illinois, Florida, and Pennsylvania. All right, why those three outliers? Because the three teams competing to be the head of the MDL were located in those states, and they were filing every barbershop, dentist office, restaurant,
Salon.
They could get their nail salon that they could get their hands on, even if they had a virus exclusion in the policy. And the thing that Mike didn't mention that's important, and maybe we're in the weeds, but the thing about filing a case in which there is a virus exclusion is that if you remember, what do you need? You need physical loss of or damage to property. But if I have a virus exclusion, I don't want to plead that my place was infested with virus that caused physical loss of or damage to property. I want to plead that my damage was caused by the government order that shut me down, because then the thing that caused it was not the virus, it was the government order.
Right.
And what that means is so that therefore these cases pled very weakly on the thing that you needed to get over the hump, physical loss of or damage to property. And again, brilliant tactical move by the insurance industry. They moved to dismissing these cases not on the basis of the virus exclusion. They moved to dismiss on the basis of this physical, there's no pleading of physical loss of or damage to property. COVID doesn't cause that, and they won, and that started.
Yeah, that's really interesting, and I want to pick up on that, Professor, because in the thousands of lawsuits that were filed over coverage disputes, let's just, as it's relevant to our discussion today, talk about a typical, coverage claim for a shutdown movie production or a live event or a sporting event, right? So maybe one of you just walk our listeners and viewers through how that claim looks, and then how the typical insurer responded to those. So let's say we've got a TV production, and there's very notable cases of, you could just look them up, of many TV productions that were shut down and
Well, I think Mike should respond to that, because his firm represented.
Exactly. Mike, you were involved in a lot of those. Yeah. So sort of walk us through what that claim looked like, and then how those claims played out.
Yeah, so I mean, they look like many of the other businesses that we represent as well. So you have a shutdown as a result of safety precautions, and then ultimately government orders that are shutting down large gatherings. That then results in, obviously, as you would expect, substantial loss of profit over that time. That is then kicked off. A claim is filed with your insurance company. One little proof of loss claim that kicks off a storm. They were denied, and Professor noted, they were denied relatively in short order, but not necessarily. Some of the bigger ones, the clients that we represent, were, in my view, slow played to the point where in some instances we had to file a lawsuit without having the denial in place. What I would suspect the motivation behind that was to get these nail salons, small businesses, to get the courts to deny these claims, and then try to follow on the bigger claims. For example, on the large production houses, substantial sports teams that were filing claims as well, where we're talking not in the hundreds of thousands, but in the hundreds of millions in losses. And so a lot of those were slow played, ultimately denied, or denied by lack of communication, effectively denied in our view, and then they result in lawsuits. And those lawsuits primarily, although there have been many in state courts, those lawsuits primarily were removed to federal court where possible by the insurance companies. And then kind of put on a fast track on motions to dismiss as Professor Baker noted, the direct physical loss or damage requirement.
Why were they, by the way, why were they removed? Explain to our
Sure.
listeners why you're removed.
So a lot of our clients, if they're in California or Nevada or New York, a lot of them are based there and are incorporated either there or in Delaware or another state. If the insurance company, if there's diversity of citizenship, which is to say that if the insurance company is based or has its principal place of business in a different state, then they can remove to federal court, particularly in our disputes where it's over the jurisdictional threshold. Then they can remove to federal court, which as Professor Baker's tracking has shown us, have been much less receptive to these claims than the state courts were. I think it's important to note too in the beginning, and because I remember this, and I remember citing to Professor Baker's work very early on this point, is that this distinction between the federal and the state courts was interesting because the federal courts were almost unanimously, not completely, but almost unanimously ruling in favor of the insurance companies. The state courts, however, were not. They were much more mixed, and they were more along the lines that Professor Baker said he expected when they started this enterprise, which is that you'd get this mix. You'd get this, some yes, some no, and then there'd be an interesting push and pull as they kind of percolated up. But that happened at the beginning, and then it quickly changed within a matter of I want to say 6 months or so, if memory serves, but maybe longer. But it for a while there, we were able to say, look, it's split, and that in and of itself suggests that there's some ambiguity in how this should be done if reasonable minds are differing on this, because you got to go back to first principles, and maybe this is something that we should emphasize here. Professor Baker was talking about the direct physical loss or damage requirement. That's been the catch. That's the significant issue in a lot of these claims. And under insurance law, if there's a reasonable interpretation that is in favor of coverage, and that's not the most reasonable interpretation, it's as long as you have a reasonable interpretation that results in coverage, that interpretation must govern. And again, it doesn't matter if the insurance company's interpretation is perhaps more reasonable, or you think it's more reasonable. As long as the policyholder posits a reasonable interpretation that results in coverage, that interpretation governs. And so when you look at this early split between all of these courts saying, well, yeah, there's and the review article that was done prior to the pandemic that says in some instances you need this structural alteration, this hard alteration, but in other instances, no, you don't. You just need the use of the property to be substantially impaired so that you can't use it for its intended purpose, or that it's just dangerous, that the property is rendered dangerous by these by certain whether it be noxious gases, what have you, asbestos, and therefore you're not able to use it. And that's really the response to the insurance industry's line on this direct physical loss, which is, well, you didn't have to repair anything, you didn't have to fix a wall, you didn't have to rebuild a roof, so there's no direct physical loss or damage. But that's not how that phrase has been interpreted historically prior to the pandemic. Instances in which the property is dangerous to use but don't necessarily require remediation, for example, smoke. I mean, there might be some smoke damage that you have to paint over or what have you, but there's not a structural alteration that is occurring. It's just dangerous to use. It's dangerous to be in the space while that loss is occurring. And so we would argue that and have argued, obviously, that coronavirus fits within that same mold, where the presence of the virus renders the property dangerous to use, which is why we have these productions shutting down, which is why we have these live venues not being able to put on events for our sports and entertainment clients, because it's dangerous at the time, and still, less so now, but still is. There's danger to be congregating in such large groups, and so that results in a loss of use of the property. You can't use a stadium for its intended purpose if you can't have people in it. For the same reasons that the courthouses, and I had some interesting arguments where, you're having attorneys and courts say, look, we can't get together. We can't have this argument about COVID-19 in person because it's dangerous to be here in this courtroom, but the presence of the virus doesn't cause for physical loss or damage.
Yeah, that's really interesting. I want to go to you, Professor, in a second, but we try to give our listeners and viewers some takeaways and practical takeaway from this discussion that's fascinating from what Mike just said over the last few minutes is, remember, like, removal is a strategic decision, right? And to Mike's point, as long as you meet diversity, as long as you meet the $75,000 damage threshold, most insurers do want to remove to federal court for the reasons we're talking about. You're going to do probably better in federal court than rolling the dice with some state courts, for a lot of the reasons Mike discussed. So that's a really interesting sort of takeaway here. But Professor Baker, let's jump in, move this discussion a little bit forward, and let's talk about your COVID coverage litigation tracker, because you actually dove in and looked at thousands, literally, of these lawsuits, and pretty revealing. Your research revealed some pretty fascinating things.
Sure. So I mean, one thing that we did, I mean, a bunch of what we did is really pretty simple counting. Like, just we tracked when were cases filed, and and what was one of the kind of interesting things is the filing of the cases sort of tracks the rise of COVID. That there was a couple waves in the filing of cases that more or less matched the waves of COVID. And then the second thing or another thing that we've tracked is that the nature of the claims that were filed changed over time. That you see fewer and fewer claims being filed with virus exclusions as the courts are ruling. And then another thing is that this really kind of backs up some of what you could say sort of more anecdotal points that Mike made, is that we do see that the bigger claims were filed later. Your NFL teams, your basketball teams, your National Hockey League, your United Talent Agent, your big cases of the sort that Mike's firm represents were filed later. Another interesting thing is we've been tracking, trying to get a handle on to measure the strategic decision. And here's one little factoid that I think illustrates the strategic, is that FM, which is arguably the premier property insurance company in the world, represents your high profile, high limit insureds, didn't file motions to dismiss for quite a while. Why? Well, because the FM policy has some bells and whistles in it that are a little more favorable to the policyholders. And I think even more significantly, FM faces Mike's firm, faces Covington and Burling, faces Blank Rome, faces Robin Cohen, faces the people who really know what they're doing. And, they let the nail salons, the barbershops, the dentist offices, whatever, develop a kind of wave of favorable results before they stepped in and filed their motion to dismiss. If you let me share the screen, Rich, I can show you the feature that I'm currently most excited about, which is our we have a map now that shows you a couple different things, which is I think maybe Mike, you might be the host now. I'm not sure, but someone needs to allow me to share. So on the one hand, people would argue it's all over except for the shouting in the basic property insurance cases, not the event cancellation or cast insurance cases, which Mike's talked about, which are different. You could, on the one hand, people argue that it's all over, but the shouting, because the federal courts have largely come out in favor of the insurance companies. But insurance law is state law. At the end of the day, it is not a federal question as to what the meaning of an insurance policy is. It's a state law question. And in fact, for the lawyers on the committee, on the podcast, who remember civil procedure, they probably remember Erie versus Tompkins, which is the famous case that said that federal courts are supposed to apply state law. Well, what even people that remember Erie versus Tompkins don't always remember is the case that Erie versus Tompkins overruled was called Swift versus Tyson. And Swift versus Tyson was a federal Supreme Court case in which the court said, hey, federal judges can interpret contracts just as well as state judges, and so therefore we should have a federal common law of contract interpretation. We don't need to defer to the states. And yet ironically, what's happened in this case, that the federal courts raced ahead interpreting these policies, the interpretation of which is ultimately a state law question, did not certify those questions to the state Supreme Courts, even though, in my opinion, they were open. That December 2019 thing shows it, with two exceptions. There was a district court in Ohio that certified to the Ohio Supreme Court, and a district court in South Carolina that certified to the South Carolina Supreme Court, which heard oral argument on that case yesterday. But everyone else raced ahead and decided, making what are known as eerie guesses, meaning they're guessing, they're predicting how the state Supreme Court and the jurisdiction would resolve. But this map here shows you the state of play in the state courts, which is that most state courts have not weighed in at the appellate level, which is really where it matters, have not weighed in at all, and that so far in only 2 states have the highest courts weighed in, Iowa and Massachusetts. And the Iowa Supreme Court weighed in a way that is actually potentially helpful to policyholders. That the Iowa case was a case where the policyholder didn't allege the kinds of things that Mike's firm would allege on behalf of his clients, namely COVID was on the premises, it messed up the HVAC, it did all the things that policyholders alleged that it did. They didn't allege any of that, and so the court said, well, you didn't allege anything like that, so therefore there can't be physical loss or damage, therefore leaving open the question of whether that could be satisfied. By contrast, the Massachusetts Supreme Court, Massachusetts Supreme Judicial Court of the Massachusetts basically slammed the door on COVID cases, and and then there's the intermediate appellate courts have come out in a split way, as my map reflects. And I do want to say there's 3 Supreme Courts. Also, the Wisconsin Supreme Court went along with the Massachusetts Supreme Court. So that's where we are today. The action is in the state Supreme Courts.
Just picking up on that last issue. So, any of these headed to the U.S. Supreme Court, you think? And given how new these issues are, we know the Supreme Court likes to take on different issues, new issues, and given the current makeup of the court, how do you think they would view this?
I think there's a 0% chance that the Supreme Court will take it, because this Supreme Court, as a matter of at least lip service, favors federalism. So that for the state, the only way that the Supreme Court could take a case and still be kind of consistent with Erie versus Tompkins would be to say, oh, you lower courts, you messed up by not certifying, or you messed up by not following state law. Whereas this Supreme Court is not going to say, oh no, we get to decide what the meaning of insurance policies sold in Kansas is. They're going to say that's for the Kansas court. So I don't think so. And the reality of insurance law as a result of this is that we have a kind of checkered, there's many issues in insurance law where California might differ from New York, which might differ from Florida, and how they handle some of those. And that's one of the features of our federal system that's enshrined. There's even a federal statute called McCarran-Ferguson Act, which says, hey, that insurance is a state regulated industry, and that's true not just of solvency and all that kinds of regulation, but it's also true of how the insurance policies are interpreted, which is a part of contract law, which is considered state law.
All right, so let's wrap up with this question for both of you. Mike, we could start with you. So in the wake of these overwhelming decisions in favor of insurers, at least in entertainment and sports COVID claims, are policies now being written differently? What kind of takeaways are both sides in this litigation having, and how will these claims be handled going forward, do you think?
Yeah, no, that's a reality of my job is insurance is written to deal with things, unforeseeable sometimes events in the future. When they then are foreseen, then they are addressed in the policy, or when my argument is realized, they then are addressed in the policy. So we're seeing a lot of claims a lot of policies now that are being when they're being underwritten, they're including a virus for a specific COVID-19 exclusion to deal with that. So I think going forward, it's going to be explicit. It's going to be explicit exclusion. But notably, in a lot of these claims, we have a case right now with a client who's was renewing their policy in March as the COVID-19 pandemic was picking up, tried to put in a virus exclusion, and then ultimately didn't do it, which would then seem to be pretty indicative of the fact that the policy could cover it if you're trying to exclude it. But nevertheless, courts have not has been as accepting of that argument. The one long term, so I think in terms of the market, you're going to get exclusions. The one long term implication of this, Professor Baker was talking about the allegations that we include, and I don't want to get into the detail too much, but we do include substantial allegations about presence of the virus both in the air and on surfaces and the danger it poses. But courts by granting motions to dismiss or demurs on that issue, and essentially, in my view, casting aside the factual allegation, our ability to prove that factual allegation that it caused physical loss or damage, puts policyholders and I'm interested to see where this goes, but puts us in an odd situation where the courts can say, notwithstanding your factual allegations of loss, we don't think it happened, based on not on our expert understanding of the virus, but based on our general understanding of news media and what we've read. And a lot of people have, I'm not suggesting that that what they're reading was necessarily incorrect, but they're imposing their own understanding of a scientific thing that we still are learning more about on a day-to-day basis, and making judicial rulings that impact hundreds of millions of dollars on that understanding. And I think that's going to be, setting aside the individual impacts on my clients. I think it's a long-term impact that will be interesting to track and interesting to see if this is just a one-off, a unique circumstance where the courts just wanted to dispel these claims and took the easiest road to do that. Or if this is going to have more of a lasting implication on pleading standards and what you need to allege in order to get past a motion to dismiss. So it'll be interesting to see.
Professor, last thoughts on that same issue?
I totally agree. I mean, the question is this going to be Bush versus Gore that never gets cited and never talked about but turned an election, or is this going to be a harbinger of what there is to come? And what I will say is that in the federal courts, there's been a trend supported by the Supreme Court to have district courts, trial courts, become sort of tougher filters for cases to be able to go forward. And we haven't before seen the impact of that in the insurance arena. Wouldn't you agree with that, Mike? And this may be the first instance of a broader trend in the insurance arena. And it hasn't been as true in the state courts. In other words, the state courts have been slower to do that, as illustrated by my map. And the state courts had often rejected this kind of new kind of gatekeeper role for trial courts. But so even here, maybe there's been some push in that direction, even though not as strong as the federal courts. So Mike and his firm didn't used to worry about motions to dismiss very much, whereas now I think they're going to be thinking a lot more about crafting their complaints more generally to stave those off.
Well, we've covered some really interesting rip from the headlines topics over the last couple months here, but who knew that coverage would be so exciting, right?
Right.
I mean, sometimes coverage gets a bad rap that it's boring, but this is fascinating stuff. It really is. I really want to thank Michael Gehrt from Pasich LLP, and Professor Tom Baker from the University of Pennsylvania. I want to remind our listeners and viewers of our next podcast. This will be next week on June 14th. We've got a great panel discussing music copyright lawsuits. We've seen dozens of them lately, and the most recent one filed this week is against Mariah Carey. Someone is alleging that she ripped off basically the All I Want for Christmas Is You song from someone else. One of the most successful songs of all time, certainly the most successful Christmas song of all time. So we'll have an interesting panel on that. Professor, you want to tell us your favorite Christmas song of all time? We'll go to Mike also on that.
I'm dreaming of a white Christmas, right? There
you go. Mike, what's your favorite all-time holiday or Christmas song?
On the spot, I'll go with my mom's. I'll go with Little Drummer Boy.
There you go. I'm a big fan of the Hanukkah song. As a man who celebrates Hanukkah myself, I love the Sandler Hanukkah song. But
that's a good one.
Oh yeah. Well, I mean, I celebrate Hanukkah also, but I do know, not a few of the Christmas tunes were written by people who themselves celebrated Hanukkah. So
There you go. There you go. Little fun fact. Professor Mike, thank you so much. Great discussion. And we'll see you next time on the SERMAPod.